Hello, my name is Morgan Inkeman, and me along with Brittany Smith and Bryce Query are the defendants in this case representing the state of California. In July 2020, the state of California had in place a stay-at-home order and didn't allow churches to practice in person. The Western Shore Community Church filed a lawsuit against California. The Western Shore sought a temporary restraining order asking the U.S. District Court for the Southern District of California to order state and county officials to move in-person worship services from Phase 3 of California's reopening plan to Phase 2. Moving in-person worship services from Phase 2 would permit Western Shore and other churches to begin holding in-person worship services again. In support of their request for the restraining order, Western Shore agreed to abide by certain social distancing measures. The state of California opposed the request of the restraining order, explaining it had consistently stated all large public gatherings, including religious services, to Phase 3 because large public gatherings pose a heightened risk of the spread of COVID-19. We will now tell you the 3 reasons the state of California was allowed to oppose.
The state of California has what is called regulatory powers. This is also referred to as police powers, which means that they can regulate private activities in the attempt to keep people safe. This can be to protect public order, health, safety, morals, and the general welfare. In the case against the Western Shore Church, we are purely considering the interest of the people of California and their safety. They have a right to health, both in the church and outside of the church. Therefore, the state of California has the right to regulate.
Although an individual has the right to assemble for religious purposes, the state of California reserves the legal right through the restrictions must be necessary in the Exercise Clause to reasonably limit religious gatherings. The restrictions must be necessary states that if the state feels as if public safety is at risk, the individual rights must give way to the government's interest in protecting the public. Due to the highly infectious nature of COVID-19, the state of California has a vested interest to protect its citizens by limiting large indoor gatherings. Because the plaintiff's religious practices work against the public policy, we, the state of California, hold that our policies and enforcement of them are within the bounds of the law.
Furthermore, the state of California is permitted to deny the restraining order requested by churches because of the public welfare exception, which states when religious practices work against public policy and public welfare, the government can act. In this case, the state of California placed a stay-at-home order regarding in-person religious services. The order was put in place to protect public welfare since in church you are singing and worshiping and COVID-19 is spread through respiratory droplets. It can lead to the spread of COVID-19 to large gatherings of people. So their choice to deny the churches to worship in person was for the safety of the public of California.
To conclude, we have clearly shown why the state of California is permitted to not allow churches to move to in-person services. First, because of the regulatory power of the state that allows them to regulate private activities to protect public health. Secondly, the restrictions must be necessary clause, which allows for restrictions of religion by the state in which it has public compelling interest, in this case, COVID-19.
Lastly, the public welfare exception states that when religious practices work against public policy and public welfare, the government can act. All 3 of these laws in the Constitution clearly allows for California to deny Western Shore to move to Phase 2 of in-person services.